Very good afternoon, each one of you. At the outset, I would like to congratulate Retailers Association of India for this excellent program, and I thank them for the opportunity given. I think the time given to me is 30 minutes. I'm not very sure. I have around 15 slides, and definitely each slide will have 4 or 5 points. I'm not very sure whether I'll be able to complete all the 15 slides in this given allotted time. Still, let me try my best. I think Mr. Rajkumar started with calling it as VUCA world. It is not merely VUCA world now. Not even VUCA multiplied by VUCA. After the pandemic, the situation is like VUCA raised to the power of VUCA. That is how it is. Where I think the complexity is more related to, I would say, the labor legislations. And I think attempts are being made to simplify it. And that is one reason for coming up with labor codes. And I think it all started sometime in 1991. I think the economic reforms, liberalization, privatization, globalization, happened sometime in 1991 under, I think at that time, Mr. P.V. Narasimha Rao was the Prime Minister. Industries have been asking for the corresponding labor reforms since that time. Unfortunately, there was not much effort for the next 10 years. Sometime in 2002, I think under the stewardship of Mr. Vajpayee, the second National Commission on Labour was formed to study the existing set of labor legislations. And the study got completed in 2004, and they made a recommendation to come up with 5 codes instead of the existing set of central labor laws. Again, in 2004, the political scenario changed. So again, for the next 10 years, absolutely there was no movement with respect to this aspect. Then again, from 2014, the efforts are made, and particularly in 2019, the codes were passed in both Lok Sabha as well as Rajya Sabha. But again, as you are aware, the subject, whether it is labor or industrial dispute or social security, being the one which is falling under the concurrent list of the Indian Constitution, I think there must be a cooperation between both central government as well as the various state governments. Only then we can implement it. So since many of the states have not yet completed the drafting of rules, it is still getting delayed. And the idea is, whatever change we are talking about under the labor laws, it is only in the central sphere. So whatever state laws we have, that will continue to operate even after the implementation of these codes. And some 29 labor laws are now being made as just 4 labor codes. I'll just try to give the overall idea of these codes. And again, people were talking about technology. This session is slightly different from other sessions. But of course, leveraging on the technology, the compliance can be now ensured using technology. That is, I think if the codes are implemented properly, ultimately that should bring in transparency, accountability, and that should also time-based. And again, it should usher in the compliance culture. Fortunately or unfortunately, many of the employers, even today I am saying big corporates, they are trying to understand the law, not for complying with it, but to circumvent it. That is a kind of unfortunate situation, but that is being also addressed through these codes. And ultimately, it is ease of doing business, and it is to bring in a lot of industrial enterprises into the country, which will automatically generate employment opportunities. That is the idea. And so these are all the 4 codes which are proposed. So 29 central labor legislations. Code on wages that will consist of the current 4 laws related to wages. Right? Payment of wages, minimum wages, payment of bonus, and equal remuneration. Similarly, Occupational Safety, Health and Working Conditions Code that will consist of existing 13 legislations starting from Factories Act, Mines Act, Plantation Labor, Contract Labor, Interstate Migrant Workers, Building and Other Construction Workers, all these legislations. Then Code on Social Security, yes, PF, ESI, maternity benefit, gratuity, all these 9 legislations will find place under Code on Social Security. And the industrial relations, typically the Industrial Disputes Act, the Standing Orders Act, and the Trade Unions Act. These are the 3 existing legislations which will get subsumed into one code called Industrial Relations Code. Yeah, so this is the status of rules by the states out of 37 states, including the union territories. For code on wages, I think 32 states have completed. Right, still 5 are remaining. And Occupational Safety Code, only 25 states have completed drafting of rules. Social Security, 27 states, and Industrial Relations, 28 states. So once all the states are on board in completing the framing of rules, only then I think this will be implemented. And of course, there are quite a few moot points about which both the trade unions as well as the employers were still discussing with the government. They are checking whether there is a possibility to change it. So these are all certain common features. Now I think you must be aware that when we say registration, we may have to do registration under PF. We may have to do registration under ESI, registration under Contract Labor Act. We do registration under the Factories Act. There are multiple registrations. But once the labor codes are implemented, it is going to be only one common registration. So it will not get duplicated. And fixed term employment, today, in fact, except in 1 or 2 states, it is not possible for the employers to recruit persons on a fixed term basis. So once you recruit a person and he completes 1 year, then you may have to carry that person till he attains the age of retirement, could be 58 or 60. Right, but now through the courts, the government allows the employers to recruit persons for a specific period. I mean, it is more based on the business situation. So you can recruit person even for a perennial job, say for a specific period of 3 years or 4 years or 5 years. Right, but for that period, from day 1 till the end of that period, that person will be treated on par with the regular employees, permanent employees. And he will be entitled for all the benefits which are available for the permanent employee. And the inspector cum facilitator, now we call enforcement authority as inspectors. Under various departments they are there. But they will now be considered as inspectors cum facilitators, because facilitation comes first. They will advise, they will guide both the employers as well as the workers. Still, if the employer is not complying, only then they will go in for action. So their job portfolio is slightly, it is going to get changed. And compounding of offense. See, in case of any contravention of any of the laws, for the first time, the employer will be left with just payment of 50% of maximum fine prescribed for that contravention. There will not be any severe action, but that will be available only for the first time. These are all certain specific features which are coming up through the courts, and it is there in all the courts. And again, we know certain key terms, say for example, wage. It is defined in each and every legislation, and the definition is also changing from one legislation to another legislation. But now attempt is being made through the courts to come up with common definitions. So these are all certain key terms which will have almost, I won't say 100%, almost common definition. Contractor, contract labor, employee, both the term employee as well as worker, both are defined. And employer is also defined. Employer will now specifically include contractor. So in respect of the contract workers, the liability in most cases, it will just stop with the contractor. And establishment, then wages. I think this is where the employers have some concern. The major change which is coming up in the definition of the term wage is the exclusion portion of the monthly salary of an employee. It cannot go beyond 50%. Today there is no ratio, right? But through the courts, this is the exclusion portion. It is capped at 50%. So this may have major impact for the companies in case if in their salary structure the wage portion, the inclusive portion works out to less than 50%. This will have impact on PF, this will have impact on ESI, and more importantly, this will have impact on gratuity, right? Suppose, assume 10,000 is the salary. Today, the basic and DA portion works out to 2,000 or 3,000 only. Rest, I think people call it as allowances, and 7,000, it goes for allowances. So the exclusion portion is 7,000 out of the 10,000, which means it works out to 70%. Today, it is not being questioned because this is right as far as Minimum Wages Act is concerned. It may not be right for other purposes, but still, it is being allowed. It is not strictly questioned as on today, right? But if some company has a structure like this, then they may have to definitely revisit. At least they may have to make the exclusion portion coming down to 50%. So which means the inclusion portion should be at least 50%. It should work out to. Still, if the company continues to have this structure, even after the implementation of the codes, then automatically 50% will be considered as wages. And for any calculation, they will not just take 3,000, but at least 5,000 they will consider. That is going to be the impact. And specific to minimum wages, today there is a schedule attached to the Minimum Wages Act. Only for that scheduled industries, the Minimum Wages Act will be applicable. But once the codes are implemented, it will be applicable for all types of industries, provided minimum rates of wages are prescribed by the appropriate governments. And there is going to be two concepts. One is the floor wage and another one is the minimum wage. Minimum wage, the appropriate governments will continue to fix the minimum rates of wages. So it will be both by central government as well as various state governments. But the floor wage is introduced, which will be fixed by the central government. And the catch here is the minimum rates of wages to be fixed by the appropriate government cannot be less than the floor wage. So that is the catch here. Then HRA, today it is considered as part of wages, particularly for minimum wages purposes, but through the courts, it is excluded. It will not be treated as part of wages. And again, the monthly salary is capped at 24,000 for the purposes of payment of wages. If an employee is drawing more than 24,000, then he will not come under the purview of the payment of wages. That is the position today. But that ceiling is getting removed, which means irrespective of the quantum of salary a person is drawing, he will be considered as employee under the Payment of Wages Act. And wage settlement, it is to be made within 2 working days after the actual date of relieving. Even today, that is the position. But again, even for resignation cases, this is going to be the situation. Even those persons whose services are terminated because of his resignation, their wage settlement is also to be made within 2 working days. And payment of wages, today the position is if the industrial establishment engages less than 1,000 workers, 1,000 employees, then the payment should be made within the 7th day of the subsequent month. But if it is more than 1,000, then they can go up to 10 days. So they can make the salary payment before 10th day. But that provision is again getting removed through the courts, which means irrespective of a particular industrial establishment is engaging less than 1,000 or exactly 1,000 or more than 1,000 employees, they may have to pay the salary, disburse the salary within 7 days. So this is specifically with respect to payment of wages. And bonus ceiling, currently those people who are drawing less than 21,000 per month as salary, they alone will be eligible for payment of bonus. That ceiling, it is common and it is applicable for all establishments across the country, but now powers are given to the appropriate governments to fix the ceiling through the courts. So we may have to wait for the government gazette notification by the central government as well as the various state governments. So the impact could be, this bonus ceiling could vary from one state to another state. So we may have to check the government gazette notification. And in addition to violent behavior or riotous behavior causing damage to the company, for which the employees are not entitled for payment of bonus for that accounting year, now the conviction for sexual harassment is also added. So in that situation also, the person will not be entitled for getting bonus. And bonus to be paid only by way of giving bank credit. And today, yes, we may pay it by way of cash or by issuing check or even by giving bank credit. But through the courts, it should be only by way of the modus, by giving only a bank credit. And principal employer, he is liable to disburse wages, the monthly consideration to the contractor. Because as I said, the 7 days is the timeline for payment of wages that is available for the contract workers also. So if the contractor has to make the payment to his workers within 7 days, in the first place, he must get the payment from the principal employer. Right. So in most of the cases today, what has happened, there is no link between the payment consideration, monthly consideration to be paid by the principal employer to the contractor and the contractor to the contract worker. Right. But now through the courts, the link is getting established. And so within 7 days, the principal employer has to make the monthly consideration to the contractor. Only out of that payment, the contractor has to in turn make the salary to his workers. That is the idea. Again, in case if the contractor as employer, if he does not pay bonus to his workers, then the liability will pass on to the principal employer. At least he has to pay the minimum 8.33 rate bonus to the contract workers if it is not paid by the contractor. Yeah, again, the applicability of the Contract Labor Act. Now, today it is applicable if there are 20 or more contract workers. That is, that threshold limit is now getting increased to 50. It is both for the establishment as well as for the contractors. And core activity is now defined under the Act. Currently, it is not defined except in case of Andhra Pradesh. But now, through the courts, this is defined. So for the core activities, it cannot be entrusted to a contractor. You cannot engage as employer, contractor, and the contract worker for carrying out the core activities. Non-core activities, yes, you can do that. And common license. Today, the contractor is supposed to take license in respect of each establishment. But in the state, within the state, if the contractor is serving multiple establishments, now there is a possibility that he can come up with a common license. It is possible through the courts. And contract labor, now what has happened, the contractor, once he secures the job from the principal employer, he carries out the job by engaging two types of workers. One is, since he himself happens to be company, legal entity in many of the cases, he does it with the support of his own employees. So he will not be recruiting, hiring persons specifically for this project. So these persons will be already available with him as his workers. So that is one category of persons. Another one is the contractor will specifically hire persons for this project, right? Now, both these classes of workers are considered as contract workers today. That is how the situation is, even though the legal position is something different. Right? But under the codes, if the codes are implemented, the persons who are already the employees of the contractor, they will not be treated as contract workers, even though if they are involved in the job which is entrusted to the contractor. Right, so that is going to be a major change. So the number of contract workers can come down because of this. And principal employer responsible for amenities. Today, whatever amenities, starting from providing drinking water, it is the responsibility of the contractor primarily. Only if the contractor fails, the liability passes on to the principal employer. But through the courts, the liability is directly latched on the principal employer. There will not be any responsibility for the contractor in this case. Then interstate migrant workers, again they are necessarily contract workers, because only those contract workers who are hired in one state through or by a contractor to work for an establishment which is situated in another state, they are considered as interstate migrant workers, right? But in addition to this, even in case of direct employees, direct recruitment, direct workers, if a person is hired from different state to work for an establishment which is situated in a different state, then he can also be considered as interstate migrant worker. So direct employees are also now included. They are also coming under the purview of the interstate migrant workers. But one catch here is, again, provided the salary of these persons is less than 18,000 per month. If it is more than 18,000, whether he is directly or even through a contractor from other state, he will not be treated as interstate migrant workers. And report of fatal or serious bodily injury, particularly with respect to the interstate migrant workers, the idea is now, yes, we will submit the report, accident report, to the authority concerned, wherever he is working. But in addition to that, the report is also to be submitted to the authority who is there in his home state. So that is going to be the change as far as ISMW is concerned. And now we will be paying displacement allowance to interstate migrant workers only at the time of mobility from his home state to the destination state. But that is now removed. It is not, the employers are not required to pay displacement allowance after the codes are implemented. And public distribution system, again, they will be entitled, the interstate migrant workers, and it will be at their choice. They can get it, they can avail it in the home state or the destination state as per their choice. And the appropriate government is supposed to extend toll-free call facility. They may have to come up with schemes for that. And yes, Factories Act, again, if the manufacturing activity process is carried on with the aid of power, there must be 10 persons. If it is carried on manually without the aid of power, then there must be 20 persons. That is the threshold limit for a premises to become a factory, right? That threshold limit of 10 and 20 is now getting changed as 20 and 40. So in case if the manufacturing process is carried on with the aid of power, then there must be at least 20 persons. If it is carried on without the aid of power, then there must be at least 40 persons. Only then that premises will become factory. Then you will start doing the registration and other compliance activities under the Factories Act. And night shift for women. Today, it is prohibited. It cannot be, women employees cannot be engaged in factories during the night shift except in Tamil Nadu, because there is a judgment by Madras High Court which said the particular section which prevents engagement of women workers during the night shift is unconstitutional. So only in Tamil Nadu, even today, they can engage women employees during the night shift, but not in other places. But once the codes are implemented, they can be engaged, provided the woman worker has to give her consent for coming and working during the night shift. Similarly, overtime work for the workers. So they may have to give their consent. Only then the employers can engage workers to do overtime work. Independent director, you must be aware again, whoever is working in factories, I'm not very sure, since this is a retail association, I'm not sure whether there is any person who is working for a factory, but still, one of the directors of the board, he is to be nominated as an occupier as far as a factory is concerned, and that is to be communicated to the authority concerned. But point here is the independent director cannot be nominated. So that is the new provision which is coming through the courts. So it should be one of the whole-time directors. And threshold limit for appointment of safety officer. SO is safety officer. Currently it is 1,000 workers. If the factory has 1,000 or more workers, then they may have to appoint one safety officer. The 1,000 is coming down to 500. Similarly, welfare officer, WO. Currently, the threshold limit is 500. If a factory is engaging 500 workers, then they may have to have their own welfare officer. That 500 again is coming down to 250. So and with respect to canteen, if there are 250 workers, then the factory has to provide a canteen. That 250 again is coming down to 100. So these are all the changes through the courts. And the qualifying number of days of leave. Every worker who is working in a factory, he will become eligible for leave provided he works for 240 days in a continuous period of 12 months. Instead of 240, that is now coming down to 180. So it is sufficient if the person has worked for 180 days in a continuous period of 12 months to become eligible for leave to be available in the subsequent years as per the Factories Act once the codes are implemented. And appointment order. Today it is not a mandate, be it a factory or a mine or a plantation or a commercial establishment or even a hotel, whatever it is. Today there is no mandate except in one or two states where those states specific Shops and Establishments Act provide for that. Otherwise, there is no mandate to issue appointment orders specifically for the workers or the employees. But once the codes are implemented, it is a mandate. It is a must. The employer must issue, even for the existing employees, if it is not done already. They may have to do that. And health checkup for every worker working in a mine or in a factory, annual health examination is to be done by the employer within 120 days from the beginning of the calendar year, which means roughly before April 30th, they may have to complete the annual checkup. And the entire cost is to be borne by the employer. So it cannot be claimed from the worker concerned. And for transgender, like we provide whatever amenities we provide as per the provisions of various legislations, now it is done separately for men and women. But once the codes are implemented, it should be done both for men, women, as well as transgender persons. Because I think it is a kind of social inclusion. Engagement of transgender is also getting encouraged. And currently we know 15,000 is the salary ceiling for the purpose of PF. But given the definition which is there in the draft now under the codes, not very sure whether the same ceiling will be available under PF for the persons. It will be available under pension scheme. It will be available for EDLI scheme. But whether it will be available for PF or not, it is not very sure. We may have to wait for the drafting of PF scheme because that is still pending actually. Then determination of number of employees. See, for establishment, for the PF Act to become applicable, there must be minimum 20 persons. Now there is a doubt whether we should include only those persons who are drawing less than 15,000 or we may have to count those persons who are drawing more than 15,000 also. There is a doubt today, but both these types of employees are to be counted to come to a conclusion about the number of employees working in that establishment to come to a decision whether this will be applicable to that establishment or not. And very specifically, the apprentices under the Apprentices Act are excluded from the definition of the term employee. Today, apart from that, companies are engaging apprentices as per the provisions of the standing orders, as per their own policies. And all these types of trainees are now exempted and they are not covered under the PF Act. But as per the draft of the code, only apprentices under the Apprentices Act are excluded. So again, we may have to still wait for the PF scheme. If there is anything mentioned there relating to this, then we can go with that. Otherwise, the trainees engaged as per the policy of the company or trainees engaged as per the standing orders of the company, they also may have to be treated as employees and made as members under PF. And under ESI, today voluntary coverage is not possible, but it is there under PF. So for ESI also, voluntary coverage is brought in through the courts. If there are 10 or more employees working in an establishment, then that establishment is to be registered under ESI. We all know that. But if it is less, say, particular establishment is having only 9 persons, if the majority of the employees are agreeing and the management is also agreeing, then they can go for voluntary coverage. Today it is not possible, but after the implementation of courts, it may be possible. Similarly, plantation. Today it is not applicable, but it is made as an option. If the employer wants, they can cover their plantation under the ESI Act. That is possible. And in case of establishments engaged in hazardous activity or life-threatening activities, it is not number 10, which is the threshold. Even if there is only one employee, if there is a direction from the central government, then that establishment is to be covered under ESI Act. And in case of accident, while commutation between home and the office, that will be treated as employment injury. Today, that is not the default position. Of course, we will apply the theory of notional extension, but now the default position would be during commutation, right? Whether it is coming to office or while going back from office, if accident is happening, then that will be by default deemed as employment injury, and the employee will be entitled for all the benefits. And in case if a particular employee is not covered under ESI or covered under ESI, but his contributions are not remitted by the employer, still the ESI corporation can continue to provide them with the medical facilities. But whatever cost incurred, that will be recovered from the employer concerned. And yes, mines today again ESI Act is not applicable, but once the codes are implemented, if there are 10 or more persons working, then the mines are also to be covered under ESI Act. Yeah, so these are all certain common points again. Gratuity, FT is fixed term employees. If you are engaging persons for a fixed term, even if it is for less than 5 years, when you relieve them, you may have to calculate and pay them gratuity proportionately, right? So the minimum period of qualifying service of 5 years of continuous service is not applicable for fixed term employees. And for providing crèche, if there are 50 or more employees, then that establishment has to provide a crèche. Then Building and Other Construction Workers Act, that is BOCW. And it will not be, if any construction is carried out in a factory or in a mine, this will not be applicable. That is number 1. And if the construction is carried out for domestic purpose, and if the cost of the project is more than 50 lakh, then it will be applicable. Up to 50 lakh, it will not be applicable, right? So that is exempted. And Employment Information, that is the current Employment Exchanges Act. That is, now it is applicable to those establishments which are engaging 25 or more employees. That threshold 25 is coming down to 20. So even if there are 20 or more employees in an establishment, then the Employment Exchanges Act will become applicable for them. And the application of Aadhaar, I think this is going to play a crucial role. Maybe as HR persons, whenever you do the recruitment, don't forget to get the Aadhaar details of the individual, not only the individual, and also his first degree family members at least. Because in case of death of the employee, you may have to pay the benefits to the family members. At that time, it may be required. And social security for unorganized workers, again, it is part of social inclusion. I think around 50 crore workers are there in India, out of which only 10% is there in the organized sector. And the current set of labor laws are more applicable to those workers only, roughly 5 crores. For 45 crores, no, these labor laws will not be applicable. Now, through the courts, some of the provisions like social security or minimum wages that are being made applicable to even the people in the unorganized sector. Typical example, Ola driver. Nobody is an employer for him. Right? So some platform is provided. So he does the service. He gets the money from the customer. Customer is not his employer, nor the aggregator. Right? So that is the situation. So slightly through the courts, they are also now getting included. Not for all purposes, mainly for minimum wages and for other social security benefits. And this is with respect to industrial relations. Concerted, I'll complete. I'll complete. So if more than 50% of the employees in an establishment, if they go on mass casual leave, that will be treated as strike. Right, I think this is all a typical trade union situation, and for retrenchment, layoff and closure, the permission is to be obtained if there are 300 or more workers. And again, standing orders, currently if there are 100 or more, then for that industrial establishment, Standing Orders Act will be applicable. That threshold limit is now getting increased to 300. And as far as trade union is concerned, there are two things. One is registration, which is governed by the Trade Unions Act. Another one is recognition of trade union. That is to be done by the employer concerned. Right? Today it is not a mandate, except in 1 or 2 states. But through the courts, it is made as a mandate. Definitely, if particularly if the trade union has more than 50% of the workers' support, that is to be recognized. I think, thank you so much for your patient listening. I'm not very sure whether I can take up questions. Thanks again.
We're out of time, so.